Good evening, everyone. We thought we might as well start sooner rather than later because we all know what happens next, and people are already in that mood. So, good evening, everyone. Welcome to a panel on CPDP LatAm panel on judiciary in LatAm countries. And we have an excellent panel of speakers from Latin America here who flew in, or some of them are based here, but I mean, people suffered for traveling 18 hours, I heard. So let's hope we can hear something good. My name is Monica Zalnerute. I am actually not a representative of Australian Research Council. I was simply a fellow in the past. And now I'm actually based at VUB here. I'm a Marie Curie fellow here and also a research professor at Vilnius University. And with me, I have a list of great speakers. So we have Agnès Samperi from Access Now in Mexico. We have Felipe Medon from FGV, let me just check, Center for Technology and Society. And we also have Pablo, just correct if I'm wrong, Trigo? Okay, perfect. Trigo, who is a PhD researcher here at Vrije University, Brussels. So why don't we, sorry? Oh, sorry. And we have a speaker online. I'm sorry. You see what happens? Oh, there you are. Okay. So we have another speaker with us, and it's great that she could make it. It's Maria Pilar Lorenz from Argentina. Thank you for being with us. Okay. So perhaps I can share a few sentences about each speaker when their turn comes. But first, let's continue because I think, you know, like I said, we want to go and have a party too. So why don't we start with Felipe Medon, who will give us a little insight into what the courts are doing with AI and generative AI in Brazil. And then we can move on and see whether it differs in other countries, in Mexico, Argentina, and we can then move on to the discussion. So without further ado, I think, you know, Felipe, you take the floor and we see what happens.
Well, thank you so much. Before anything, I'd like to say good afternoon for those who are still here. And it's something very interesting because we are preventing you from getting to cocktail, so we'll try to make it as better as we can. Before we start, I'd like to say that this panel is a panel from the Brazilian and Latin American version of CPDP, CPDP LatAm, and we are very grateful for being here and for this partnership. I will speak a little bit about the Brazilian framework, and I will be very happy to try to navigate this scenario with you. First, the use of artificial intelligence in the Brazilian judiciary. There you go. The use of AI in the Brazilian judiciary, and also by lawyers, is increasing, and so are the controversies. In the screen, you can see that, for instance, we have two different things that are happening and taking place in Brazil at the same time. Last week, just a few days ago, one of our justices, Cristiano Zanin, he decided that he reject one of the petitions that were submitted to the Supreme Court because he realized that this petition was made up by ChatGPT, who invented some precedents. At the same time, at the other picture, we can see the Supreme Court Justice, the President of the Supreme Court in Brazil, Ministro Luiz Roberto Barroso, with Maria, one of our latest generative AI tools introduced in the Brazilian judiciary. So we'll try to cover a few topics on this presentation. First, the resolution that is now regulating this subject in Brazil. Also, current data on the use of artificial intelligence in the Brazilian judiciary, and finally, problems such as miscarriage of justice, judicial error, and data protection. To start, I have a few facts for you about the Brazilian framework. Brazil is definitely one of the most advanced countries in the world regarding the use of artificial intelligence by the judiciary. And this is largely because Brazil has had recent initiatives from the last presidencies of the Supreme Court and also the National Council of Justice, the so-called CNJ, that is promoting even the idea of 100% digital trial. The most advanced example and notable in Brazil is the so-called tool Victor. This tool has the function to filter the existence of general repercussions in constitutional actions in Brazil. In terms of regulation, Brazil is also advancing very quickly. The first regulation we had in Brazil was an administrative regulation, which is Resolution 332 from 2020. This is a very interesting regulation that was issued back then to try to give the first general rules for the judiciary power in order to cope with AI. Back then, we didn't have generative AI so widespread as we have now. But we have very interesting things from this resolution, such as it tried to tackle discrimination, biases, and that is something that remains in our updated version of said resolution, which is Resolution 615, which has been recently adopted last March. So this new resolution proposes a risk matrix for the uses of AI by the judiciary, and we also have a bill on AI on the Congress, hard law bill, which is Bill 2330, that is still being discussed. It was later approved last year by the Federal Senate, and now is under the analysis of the Chamber of Deputies. How to integrate these solutions that are more than 140 around the country and all the courts in Brazil? One of the ways to do that, to achieve this goal, is by the Synapses platform. This is a platform that promotes the standardization and interoperability of the AI systems that are being developed in Brazil by the judiciary. I have here a few data for you about a recent report published by the CNJ as well, when they interviewed judges and judiciary staff throughout the country. Among these findings, we can see the use of Gen AI in courts, and this use is significant because between both judges and judiciary staff, although we have a champion, which is ChatGPT. So far, the tool is the most used in Brazil among judiciary staff and also judges. Between the types of use, we have, for instance, research and text generation. These are the most common. And that, of course, brings us a lot of questions, especially considering the risk of hallucination from the AI systems. Another problem is regarding transparency regarding this use. There seems to be a lack of transparency, mostly when the Gen AI tools are being used by the judiciary staff that not always report to the judges that they are using these tools. So here we have main risks of Gen AI according to the CNJ report in Brazil, such as automation bias, lack of transparency, we've just said it, covered it, risks related to the protection of privacy and confidentiality, copyright infringement, something that we've been discussing a lot here, reproduction of biases, and sustainability impacts on work and competition. Just to give you a real example of something that happened in Brazil quite some time ago, it happened in 2023, we had an example of miscarriage of justice. Judge Jefferson Ferreira Rodrigues included in a ruling to deny compensation 8 non-existent precedents. And later, he attributed this simple error to one of his staff members who admitted to having used ChatGPT to search these legal precedents. So this is something that is already taking place in Brazil. But I'd like to focus on this last 5 minutes on something that is really controversial in Brazil right now, which is Gen AI training and data protection. This is one of the most relevant debates in Brazil right now. And the question that I'd like to ask you is, can judges use generative AI tools which are not provided by their courts and without contractual guarantees Could they do that? At what risks? That's one of the questions that has been brought by the late commission that has drafted the administrative resolution that we have mentioned in the beginning. And at the end, the CNJ has decided to come up with this Article 19. And Article 19 is always a problem in Brazil. We have Article 19 also for the Internet Bill of Rights, and it's also a very controversial point because it has to do with the civil liability of intermediary platforms. And this is one of the most discussed things in Brazil because by this Article 19, if the courts don't have a tool, a specific tool, they don't provide to the judges and to the judiciary staff a specific tool, they could hire a tool by themselves. And that is a very, very sensitive matter because we have to think that maybe data protection might be in danger. This is a very recent paper we are publishing on one of the books coordinated by Monica here, that we are trying to address this subject. How can Brazilian courts use AI in a responsible way and with regards to data protection in general? And here we have a very recent study published by FGV, Rio Law, at our Center for Technology and Society, by my colleagues from the project Data Regulations, that they have found out that the companies that provide Gen AI in Brazil, most of them are non-compliant with the law significantly. Just to give you an example, the study indicates that Claude, Meta AI, Gemini are the only ones that meet more than the 10 criteria evaluated. Only 3 of the LGPD, which is the Brazilian version of GDPR, requirements examined are met by all platforms. For instance, having a privacy policy, identifying the data controller, and informing what types of data are processed. DeepSeek and Grok have the worst results, failing more than half of the requirements. ChatGPT does not comply with 5 of the 14 parameters. So just to give you an example, ChatGPT is the most used tool in Brazil, and it doesn't comply with 5 of the parameters analyzed by this study that you can all have access to, and I'm pleased to share with you later on. Ultimately, this is also a matter of sovereignty and cybersecurity. That's one of the findings of our research there, because we don't have control about what the judges are putting inside these tools. Of course, they have to receive training by the judicial courts that is stated by the resolution 615, but the question still remains, where are these data going to? And this is one of the most sensitive questions that we are trying to deal right now in Brazil in terms of this widespread use of Gen AI by our judiciary. So in my final remarks, I would say that this is something that can't be stopped in Brazil. It's going, it's developing. Each day more courts are adopting new AI tools. And what we need to do right now is to discuss whether these tools are being properly implemented, making sure that all the rights are respected in this sense. So I'd like to thank you all and to invite you to come to Rio for the CPDP LatAm this coming July. Thank you so much.
Thank you so much, Felipe. That was really good and insightful. I'm very excited what's happening in Brazil and what is the potential in other countries too. By the way, one thing I need to mention that Felipe is very experienced in this field because he was part of the Brazilian Federal Senate Commission of Jurists responsible for drafting the Brazilian AI bill. So that's really, really good to have you here and be able to talk with you about Brazilian context and what's going on there. So let's move on to our next speaker. So that we can continue the discussion about Mexico and what's going on there, and maybe in some other Latin American countries too. So Agneris, I'll give the floor to you now. She is a policy analyst at Access Now in Mexico, and will share a little bit about what's going on over over Latin American context, and in particular, I think Mexico and Colombia, we'll see. So thank you. The floor is yours.
Thank you very much. Bom dia, buenos días, bueno, buenas tardes ya, good afternoon. I want to thank you for the invitation and participating in this panel, but also thank all the people that is here. I know that it's complicated. We all want to have some drinks, enjoy some chatting, but I will try to do this like a conversation. So we are here to have a dialogue together, and I will introduce you with what is happening in Mexico, Colombia, and some LatAm regions. And part of this diagnosis is that lawyers don't know how AI works. And this is a problem because there's a lack of understanding between development of AI tools, the use of these tools, how do we use them, and the use of AI systems within the judiciary. So this lack of bridges make us think either AI is a harm and will damage our rights, or is a tool that will help us for innovation and to make these judiciary processes more friendly, more rapid, and more fair and transparent, perhaps. There's people that think about that. So what do we think when we are talking about AI? Probably we are thinking about the more common systems such as ChatGPT, DeepSeek, because it's what we have like immediately. And it's also what judges and people that works in the judiciary have immediately. But there are another kind of systems that we are not facing or we are not talking sometimes. And for example, Colombia has implemented this AI tool called Pretoria. And how Pretoria works? Pretoria is not the common AI system that produces you a beautiful text or an image or a video or audio. Pretoria helps to identify and categorize cases. And this is made by an AI tool based on a decision tree. So to explain this concept, let's imagine a tree. A tree has leaves, has roots, and now you need to imagine the tree upside down. So we start with a root, and that root is a question. And what's the question that the Colombian judiciary is asking? Should this case go to the Supreme Court? And based on different categories, the AI tool analyzes the words and identify if should or not should go to the Supreme Court to analyze the case. And this system is not unsupervised. There are human review, there's human training, and there's constant update of data, which leads me to another trend topic for this CPDP, that is the data. The data, the quality of the data, the quality for training the data, the quality of evaluating the data for evaluation, the results and the outcomes of these systems is something that we should discuss when we are talking about transparency. And this is important because when the judiciary is using this kind of AI tools, we do, as citizens, as people that might need of judicial authorities, we need to understand what kind of tools does the judiciary is using, if they are using any. How do they work? How does that data is being used? Where does that data comes from? Is it legal? Does it train based upon personal data from previous cases? How they are treating this personal data? Those are concerns because we don't want our cases appear like in a weirdly way result outcome from ChatGPT question. And that's something that happened recently. A guy looked for his name, and he was being claimed to commit a crime. And this leads to the problem of hallucinations. Why people is using systems that has high rates of lead you to uncertain information. Recently, OpenAI shared the system card about the evaluation of ChatGPT 3 and ChatGPT 4 Mini, and they discover that hallucinations are getting worse. The outcomes with false information are getting worse, and the way we are using that kind of tools and the way we are accessing to that kind of information is important, not only for us being responsible on how do we use that and how do we trust that kind of tools, but also to question how does the judiciary is using that. And it's a great moment to bring an example from Colombia. Colombia is probably the first country or one of the first countries in have a ruling about the use of generative AI within the judiciary. Everything started like a case, a regular case about a child, and end up like about analyzing the rule of law and the due process within a case because a judge used ChatGPT to ask some questions about if the case follow the legal system. And this is an odd way to start discussing this issue because it was not the main problem of the case, but led to interesting results. What does the judiciary of Colombia say about using this kind of tools? It's not prohibited, but it set few standards on transparency, these principles, and something that is quite different from the European Union is the approach. The European Union, as you may know, has a risk-based approach that comes from the EU AI Act, and the case within the judiciary in Colombia is focusing on a human rights-based approach. And this is important because when we talk about rights, human rights, probably in the European Union is more understandable the interpretation, systematic interpretation, not only of the EU AI Act, but also the Charter of Rights. But when we are in Latin American countries, Latin America is not Europe. We do not trust in our authorities. We do not trust in what is happening. And probably in the rest of the world, it's quite similar. So having safeguards of how this kind of tools will be used and will be deployed, it's very important for us to have mechanisms to redress the harms that they can cause into our rights, because it's not only the due process if they are using this kind of tools. There's also many things related to our privacy, the protection of our personal data, and discrimination cases as well, because the judiciary is not the only one using this kind of tools. There are also this high rate of use of biometrics of your data, one, to prove your humanity by private companies, the private sector, as you may know, WorkCoin, and how WorkCoin is exploiting third countries and offer them tokenization, cryptocurrencies, money, even money or some AirPods in exchange of your biometrics, and to start a program of the use of your biometrics as a human proof into the digital world. Well, authorities are using facial recognition for prevention of crime and also for investigation, and have led to false positive results. And this is because, for example, countries like Brazil, like Colombia, like Mexico, we have a lot of diversity. We have many indigenous people that live there, that they are way different between each other. There's a lot of heritage from another regions and other countries, and try to teach that kind of biometric models will lead to biased results and lead to unfortunate cases like the the detention of innocent people into football stadiums, for example. Yes, I was referring to the case of Brazil where happened that, imagine you're in a football match and suddenly the police officer is like handcuffs you. It's like crazy. But at some extent, if we do not do something, if we do not understand and realize the potential impacts that the deployment of these kind of technologies may have, we hardly have the chance to fight for our rights, because human rights are not up for trade-off. Innovation without protection of human dignity is techno-fascism. And so we do need innovation. We don't need to use this kind of tools, but for use them properly, we need to understand them as well. And that's the reason I use the example of Pretoria, because Pretoria is a very friendly use of AI tools, and instead trying to reinforce the use of generative content, we should explore all the benefits that other kind of technologies may have to train and to explore the benefits for the judiciary, always with transparency and protection of our human rights. And just to close that, there are many examples for data governance that we can apply into the AI implementation and deployment of these kind of technologies. Transparency, not only about the AI models that the judiciary and the authorities are either either hiring from external sources or building in-house, which I might say that my opinion, my personal belief about that is that there should be in-house development of this kind of technologies. However, that means a lot of money and talent investment that sometimes our countries in Latin America may not have. So we need to explore how the hiring of these technologies will work and how third-party companies will protect the data that is being treated into so sensitive cases and issues, such as ruling cases. Probably, yeah, I'm okay with time. I'm okay with time. I will say that I had beautiful readings that I explore in my master's with my colleagues. We have very fruitful discussions, and the use of data sheets for transparency regarding how these models works, alongside with systems such as model cards for reporting on the AI models that are being used, it's highly recommendable for authorities, mainly the judiciary, to report on transparency. Also, make transparent the contracts when they are hiring these models from third parties, because sometimes in countries like Mexico, we have direct acquisitions with companies that are created out of nowhere, and we are buying software such as Pegasus for spy on human rights defender, activists, and journalists. So we don't want that our data end up being used by third parties that are using them for another harmful purposes. And I will finish here to give it the word back to you, and happy for you staying here, and I promise we will close quickly.
Thank you so much, Agneres. That was very stimulating, and just passionate. That's good. Always fun to listen to, and we can continue the debate after Pablo and also Maria talks. So now I would like to invite Pablo Trigo, who is a PhD researcher here at LSTS at Vrije Universiteit Brussels, and he's also part of the Cyber and Data Security Lab. And I think Pablo comes from Chile and will share his insights about what's going on in Chile, and perhaps we'll connect it also with the other discussions later. So the floor is yours, Pablo.
Thank you. Thank you very much. Thank you for the invitation. Thank you from the Society of Universities for organizing this panel about this very interesting topic. I was thinking about the Chilean case, why the Chilean case could be interesting for this kind of debate. And until now, I think that I'm not completely sure, but one of the main reasons why I think that probably the Chilean case could be interesting is because all this digitalization that we are experiencing. And I'm going to refer to that because I think that in order to deploy AI systems, you need to first to comply with certain conditions. And the first condition, particularly in this case of judiciary, is trying to have digital data in order to feed the kind of systems, fit the systems in terms of development and also for deployment. Without that, and we are going to explore this right now, it's not possible to have a trustworthy kind of use of AI. So, where's the launcher? Do you know how to use it? No? Okay. Okay, thanks. So, first, I mean, Latin America has often been characterized by slow-moving court systems and chronic delays and access to justice issues. So, the question is, what happens when digital transformation reaches the judiciary and artificial intelligence enters the picture? So I want to take a closer look to the Chilean case, considering these particular aspects, again, all this issue of digitalization. And because Chile has made great progress in building digital infrastructure in the judiciary, but still we are facing important questions about how AI should be used in this context. So it's allowed to my presentation. I'm going to provide with some background about the use of AI in the judiciary. Some of my colleagues already addressed this kind of this particular topic, but I'm going to try to revisit this very fast. So then I'm going to explain a little bit about the Chilean context, this digital transformation in the judiciary that we are experiencing. And then we are going to experience this key issue of the normative landscape that is necessary for the trustworthy deployment of this kind of AI tools. We are experiencing some kind of fragmentation, as it's the same situation as in Brazil. Then I'm going to talk a little bit about the opportunities. The use of AI in Chile right now, there is some kind of in-house kind of tools we are using. And then I'm going, as a conclusion, I'm going to, again, trying to be very emphatic in terms of emphasizing this issue of the necessity of adequate digitalization in order to develop and deploy AI systems into the judiciary. So, okay. So first, some background. Well, as you know very well, we are going to from the use of digital tools to the use of AI as an integral part of certain processes in the judiciary. So digital tools could be very useful when dealing, for example, with case management systems or when using, for example, these digital filing kind of tools. But the arrival of AI is, in a certain way, posing some different issues. So the AI is no longer just talking about improving administrative efficiency. It's more than that. It's dealing with tools that can support and in some cases can influence how judges are solving some cases. So it's having a direct impact in judicial decision making. And for example, we need to consider predictive analytics, the use of predictive analytics in the judiciary, assessing, for example, recidivism risks, and the use of natural language processing tools that can summarize some judicial opinions, can extract some relevant legal arguments that could be useful for when drafting rulings. So we are seeing that AI tools can have an impact that are going beyond, just supporting judicial reasoning. So another use that is very important is incorporating this kind of AI tools in dispute resolution. And we are seeing that the use of AI tools in dispute resolution, particularly when dealing with alternative dispute resolution tools that usually are criticized for high cost, long delays, and inconsistent outcomes. I'm thinking, for example, about arbitrations, mediation. Usually, we are seeing that in that settings, AI tools could be very, very useful. And in that sense, AI are offering possible solutions, particularly in that settings. For example, advanced natural language processing could be very useful for categorizing documents. Remember that usually when dealing in an arbitration process, the arbitrator is usually the office of the arbitrator is not so huge, so there is a lack of clerks. So in that sense, AI tools could be very useful, and we are seeing the use of this kind of tools, particularly when dealing with small claims or minor cases. For example, in consumer law or on line dispute resolution, and probably we are seeing this integration of AI, particularly in these settings, and probably we are seeing how, in a certain way, we are moving to a complete automated decision-making process in this kind of environments. So this is as a first setting the ground for this discussion, and of course, was mentioned before, all these challenges, all these concerns when dealing with AI in the judiciary. First, this issue of opacity and fundamental principles of judicial reasoning. In a certain way, the use of AI is challenging this. When AI systems, logics cannot be clearly explained, then the legitimacy of that decision is, of course, at stake. A second issue that we need to consider is this well-documented risk of bias replication. That, of course, is present in these kind of systems, and here is, of course, a decision by a court, a judge, of course, is going to have a direct impact in individuals. And finally, for me, it's the most challenging kind of topic that we need to address is this shifting locus of discretion. If we start delegating part of that discretion to AI systems, we risk eroding in a certain way the independence that judicial decision-making requires. So for me, this is the most challenging thing when dealing with the use of AI in the judiciary. So how to deal with this? So I think that probably we need to try to take this approach, this legality attentive approach to AI into the judiciary. It's necessary to consider that not because these kind of tools are being used in the judiciary, this implies that they are legal by default. In reality, that's not the case. So we need to take care of these kind of considerations, even in these kind of settings, because we are dealing with systems that at the very beginning are not, when in the design phase, they are not considering these kind of elements for these kind of considerations in order to develop this kind of trustworthy AI models. So regarding the Chilean context, we have this highly digitalized kind of approach when dealing with processes, particularly in civil courts. Chile passed this electronic processing law, and this law was tested during the COVID crisis, and the judiciary in Chile, I think that passed this test in a very good way. And this is a system that in a certain way is handling digital case files. So in a certain way, all the information linked to a particular case is in a certain way digitalized, when possible, of course. And they're trying to consider all these issues related to accessibility, transparency, searchability when dealing with these digital files, digital information. Other different topic, I think, that probably is not directly addressed with this particular law is the issue of interoperability and trying to have some kind of standardization with dealing with these kind of files. So this is a second stage that probably we should address in a better way when in possible reforms of this kind of regulations. So we have a solid infrastructure that enables this kind of integration of advanced technologies at the judiciary, but additionally, we have this other law, the Digital Transformation Law, that operates at the level of the central administration, the government that mandates this electronic communication and interoperability across public services. So this is very important because, of course, judiciary is leading with these documents that are issued by the administration, and we need to have some standards in order to deal with this kind of files. So this law, in a certain way, is contributing to the success of the judiciary when dealing with this electronic processing law. But the question is infrastructure enough for data-driven AI development? So probably the response to this question is it's not enough, of course, because in a certain way, this kind of safeguards when dealing with this kind of systems, and in certain way, in order to have a proper setting, a proper environment for when dealing with this kind of tools, AI tools, is of course necessary to have some kind of AI regulations, AI principles that should be applied in a horizontal way. There is this risk, usually in Latin America, in order to just provide these kind of regulations that are only mandatory for the private sector. You're going to start seeing some exceptions regarding the public sector, so we need to deal with these kind of considerations when discussing about the trustworthy development and deployment of AI tools. So our normative landscape, we don't have right now a comprehensive AI regulation in Chile. So, but not yet. We are discussing in the Chilean Congress a new AI comprehensive law, horizontal law. It's not sectoral. It's trying to address all different sectors that are dealing with AI. So that is very good news. But a previous consideration is the new data protection law. The new data protection law is based in the GDPR. We're taking this European approach when dealing with data protection, data processing issues. And of course, we are taking into account Article 22 of GDPR. We have this Article 8 bis that in a certain way is regulating the right to object to decisions based on automated processing, including profiling. So this provision is quite similar to the provision contained in Article 22 of GDPR. There are some differences. In certain ways, this provision, I think, is broader than GDPR provision on the right to object. But the point is that, of course, very important, how these different concepts contained in these provisions will be interpreted by the new data protection DPA, data protection agency. You know, this is very important, but we have this provision there. In principle, it should be applicable in cases that this kind of automated decision-making systems are utilized by the judiciary. So this is the first rule. In Brazil, I think that the case is more or less the same. And we have this first approach when dealing with AI systems. This Article 22 GDPR approaches when dealing with automated decision-making systems. And in Latin America, you can see that all these reforms that are trying to incorporate this GDPR approach and in a certain way considering this regulatory approach to AI. And a second issue, I mentioned this before, is the discussion of this AI comprehensive law that is horizontal. In a certain way, is inspired by the principles contained and certain provisions contained in the European Union AI Act. We are seeing some kind of Brussels effect there, but it's a watered down kind of approach still. I mean, it's very difficult to trying to make a copy paste of this huge animal that is the AI Act, but still, all the discussions we are seeing are based in the AI Act. The AI Act is some kind of model that is on the table when discussing these kind of regulations, and of course, the final outcome of this discussion, if we finally have an AI law, will have clear implications for the future judicial applications of AI. So, opportunities. So, the judiciary in Chile is developing in-house solutions, AI solutions, when dealing with certain aspects of automation, of automatic decision-making into the judiciary, and they are taking advantage of the fact that of this very deep digitalization of judicial processes. So, considering this background, this first stage, the judiciary developed this in-house system called Justa that aims at expediting case handling. So a certain way to get advantage of this digitalization of information contained in digital files. They are trying to transcribe some audios that are taking place in some judicial hearings, but enable also analysis of this audio and analysis also of some files, some information contained in these digital case files. So this is the first approach. They are using this in trial courts. They are in this pilot phase, and they are considering that the assessment of this first pilot phase is quite positive. So they are thinking about using this system in other trial courts and eventually using the system in appeal courts. So probably we are seeing more of these kind of AI uses in the judiciary. And finally, to conclude, I think that, considering all this, the Chilean case, I think that AI itself does not magically fix structural inefficiencies. So if you have this kind of basic problems at the national regarding your this digitalization, how you're handling data governance rules, and data governance structures, of course you are going to have a lot of issues when dealing with this kind of this kind of systems. So this is something that we need to have in mind when dealing with AI in the judiciary. This is a precondition that is necessary in order to have trustworthy AI tools and systems. And I don't know if, for example, Latin American countries are taking this approach into account. So probably they are just trying to incorporate for some certain kind of processes this kind of third-party AI solutions without considering this kind of considerations or this kind of elements in the deployment phase. So this is a major risk, of course. Again, Chilean experience demonstrates that digitalization is a precondition, but it's not enough. Of course, we need this kind of regulatory environment that designed in order to take advantage of these rules and trying to consider all these risks that we mentioned in our previous slides. So I think that, again, we need to keep in mind when dealing with AI to judiciary, this commitment to fairness, due process, and fundamental rights, this issue of the discretion and how this function, this judiciary function that usually humans are exercising, is important to keep this in mind because, again, this is one of the core aspects of the task that we usually give to the judiciary, and without that, it's not possible to have trustworthy AI systems, particularly when we have this kind of automatic decision-making system or something that is supporting decisions in the judiciary. So thank you very much, and thank you.
Thank you so much, Pablo. Very good to hear about what's going on in Chile, and we can continue the debate in a second. We still have one more speaker, and that is Maria Pilar Lorenz. Can we get her connected? Oh, there you are. So now we will reward you for all this waiting time. We know how annoying it is to be far away and wait for your presentation. So why don't you go ahead and give us an overview of what's going on in Argentina? We will, are keen to listen. Maria, the floor is yours.
Thank you very much. Good afternoon, and thank you for being here. Today, I'll be discussing the current state of AI regulation in Argentina, with a particular focus on its use within the judiciary. As you will see, Argentinian issues are very similar to what has been shared by the previous speakers for other LatAm countries. First, I will refer to the context of regulation in Argentina. As of mid-2025, the country lacks a specific legislative framework for regulating the development and use of artificial intelligence, both generally and within the judiciary. However, this does not mean AI is entirely unregulated. Rather, existing norms are found in a patchwork of international and national documents, and some recent protocols suggest a move toward more defined governance. Since 2019, Argentina has engaged in global AI discussions and endorsed several key instruments like UNESCO recommendation on AI ethics, UNESCO toolkit on AI and the rule of law, has joined the Global Partnership on AI, but these documents are non-binding and only guide ethical and responsible AI development. At the national level, regulations remain fragmented. Since 2018, the country has been working to establish a framework for AI, beginning with a decree number 996, which launched the Argentina Digital Agenda and laid the groundwork for a national AI strategy that was developed during 2019, and it's called Plan Argenia. It aimed to promote adaptive, inclusive AI development with an emphasis on human rights and data protection. However, this plan has not been formally adopted, and there are some discussions going on to adopt another agenda, another plan for AI regulation. Legislative efforts have increased in recent years, but no draft laws has passed through the Congress because we have several laws, several proposals, but few discussions on the topic. And regarding the judiciary, the regulation is very complex because Argentina has 25 jurisdictions, each with autonomy over procedural law. As a result, each jurisdiction has the authority to regulate how and when AI can be used in its courts. There is no federal regulation specifically governing AI use in the judiciary, though interest is growing. Since 2024, several initiatives and protocols have emerged to guide these issues, like, for example, Resolution 111 from the Ministry of Justice, that's 2024, that created the National AI Program for the Judiciary, initially focused on the federal system and not the provincial systems. And in collaboration with UBA Lab and JUFEJUS, those two institutions from Argentina, the program aims to assess the impact of generative AI on legal practice. They want to know how and when the courts are using the AI tools within the procedures. And also, there are some provincial courts actions, such as those adopted by the Supreme Court of Rio Negro and San Juan, two of the provinces of Argentina, that issues some protocols on how AI should be implemented in its courts. To better understand how AI is impacting the judiciary, I highlight three types of use cases in Argentina. Ad hoc uses, those with professional and academic support, and those with institutional backing. The first one is the most interesting, as most uses of generative AI in the judiciary are decided by the judges and employees on an ad hoc base. They involve tools like ChatGPT or Gemini for analyzing and summarizing legal documents and for identifying and comparing legal arguments. But there is one known case in which a judge explicitly mentioned using generative AI in his decision. This occurred in the 14th Civil Court of First Instance in Rosario, province of Santa Fe. In this case, the judge stated that the use of Meta's AI button on WhatsApp to fact-checking claims made by the parties did not exceed judicial responsibilities. He said that as part of his functions, he could ask the AI if some claims were true or not. Notably, the judgment did not explain why the AI tool was used, which raises concerns, obviously, about whether the judge fully understood its limitations and its risks, or what specific benefits were expected from its use. I think he used it because it was curious about what the AI will say in this particular case, but it doesn't add anything of value on the decision. The second use case refers, for example, to the program on a strategic and responsible use of generative AI in the Argentinian judiciary, led by the UBA Lab and JUFEJUS, the program that I mentioned earlier, that aims to evaluate how and for what purposes generative AI is being used in the judiciary in order to identify its potential applications. This is an ambitious initiative that seeks to map AI use across jurisdictions of varying sizes and competence, but it has mixed reactions because, for example, people from the IT context said that the employees were not capable to decide or were not the right persons to decide if AI should be used on different tasks. during the process. Finally, concerning the last use, this is the one that has the institutional support. Only 4 of the 25 jurisdictions have official documents supporting the use of generative AI by judges. Among these protocols, the province of Rio Negro and San Juan established regulatory frameworks for implementing generative AI tools in daily work of the judiciary. Others simply asked for a prior authorization for the use of generative AI on a specific process or for a specific act of a process. I've been thinking a lot about this because I'm writing a report on this topic for Argentina. And I think that we can conclude that courts are indeed using AI tools, but most do so without public disclosure. There is a notable lack of public debate on AI within the judiciary. Official responses from professional association or the academic community are absent. You don't see a reaction to these uses within the judiciary. For example, when the Rosario judge published his judgment referencing AI use, some news outlets covered it, mainly in Santa Fe, but neither scholars nor lawyers publicly reacted to this. Lawyers didn't say anything about this use of AI in a judgment. Meanwhile, the Supreme Court of Santa Fe has only issued a resolution requiring prior authorization for the use of AI tools and nothing else. It didn't revise the judgment, and there is no reaction to this. That's something that, for me, is very striking, because I don't know why nobody reacts to this. I believe several risks arise from this unregulated use of AI that we urgently need to address, including a lack of oversight, potential data protection issues, and insufficient understanding of how these tools actually work. What is the role of Supreme Courts in these debates? As the highest court, they have the authority to establish rules on how certain digital tools can be used in the judicial processes, and they are actively doing so. However, there is a need for clearer, more comprehensive rules, which likely require a broader, more open debate involving multiple stakeholders. This raises another set of questions. To what extent should AI use be regulated? Are formal rules necessary, or would standard and best practice be sufficient? It's clear that Argentina lacks of a coherent regulatory framework, yet the use of AI tools by the judiciary is steadily increasingly. This raises key questions. In which cases is it safe to use AI? Does efficiency justify its use? How will oversight of AI deployment be ensured? To conclude, I have more questions than answers, but I look forward to discussing these issues with you. Thank you very much.
Thank you so much, Maria. That's really good to listen to all of this. And now I think, why don't we start the discussion a little bit, and let's hope we can have you on board as well. So I would like to pose a first question, and then maybe we can open the floor as well to the others, and feel free to ask questions of each other. So my main question, as someone who does not really come from a Latin American country, but I've been following, of course, the field quite closely, my question to each of you would be, what do you think is the particular challenges of Latin American countries? Maybe you already addressed some of the issues, like you don't trust the institutions maybe so much, or what are the distinct challenges you think that are there? As distinct, let's say, from Europe or US, or you know, are there some specific challenges that are related? And do you think that then it gives certain advantage or disadvantage to how we can maybe regulate the field, or certain legal cultural aspects that could perhaps we could twist into some benefits, or energize the field in a certain way? So, yeah, go ahead.
I'll jump in because I have few thoughts on that. What happened with the European Union? The European Union has regulatory power. So this power is exercised through direct or indirect Brussels effect that replies to either companies that apply equally EU standards within their systems or tools or products, or in LatAm countries or any other rest of the world countries, they try to copycat EU regulations. So we have this model of the European Union having a regulatory power, and on the other side, you have US with economic power. And you can see that because we are in the middle of this tax crisis, tax war, and you have this country where the approach is no freedom, no, well, kind of, sorry, no regulation and absolute freedom for US-based companies, because of course it's US-based companies, not Chinese companies, not any other kind of companies. And what happened? What's the position in Latin America? Latin America has a lack of regional cooperation discussing these issues because by ourselves, the bigger market is probably Brazil. Then you have Argentina, you have Mexico over there, but there's a fragmentation on how to deal with these issues. And the lack of regional cooperation allows this fragmentation and not moving forward in a coherent way because we have regional treaties, regional inter-American system, for example, the inter-American system of human rights that we can use to approach this kind of challenge that emerging technologies pose. So that's one huge, big challenge. But if we can address that, and if we can work on that in the long term, we can face either the regulatory power of the EU and have tailor-made regional regulations, and we can also face the economic strains that US pose, mainly for Mexico, because one of the big disgraces of Mexico is being so close to US. Yeah. And either if we want to regulate as a country, we might have problems, economic problems with US. So right now in Mexico, you have more than 16 AI initiatives, bills that are not moving forward and won't move forward in the near future.
Thank you. So regional cooperation, sort of lack of regional cooperation, then of course some unique challenges for Mexico. Why don't we hear from other speakers as well? What do they see, and maybe some unique challenges for, let's say, Brazil now?
Well, I couldn't agree more about the lack of a regional cooperation. And that's not only for judiciary regulation on AI, that's for everything. I think that we need to encourage more cooperation within the region. So when we think about challenges, it brings me two different ideas. Challenges within the region and challenges within Brazil. And I would like to start by saying that each country has its own characteristics. And the idea of the title of this panel, which is hallucination or opportunity, came from an event in which I believe Maria Pilar was also last year. And I was presenting the Brazilian framework, and there was an Argentinian judge next to me on the panel, and he said something that I remember, and she's laughing, she's probably remembering as well. He said something kind of, well, why are we discussing AI in Argentinian judiciary if sometimes we don't even have money to change the light bulbs? That was his sentence, and it stuck to my head. The idea that AI could be at the same time an opportunity for countries in order to deliver justice in a more fair and speedy way, but at the same time, it could also bring hallucination, because if you don't have enough training, then you probably end up with not delivering justice, but probably delivering injustices. So at the end of the day, it all boils down to how are we implementing the solutions. Of course, we need money. It's not easy to design and build these tools internally. These tools cost a lot. And we also need compute capacity. And this over-reliance of foreign companies is also another problem in this sense. So sovereignty comes to the discussion. And the sovereignty not only about the data, but also about the compute reliance and how certain companies tend to come to Latin American countries hoping to explore our natural resources for unlimited reasons. So these are some of the things, but I would conclude by saying that maybe in Brazil, the two largest challenges would be the absence of training and literacy, because now we have a widespread use of AI by the judiciary, and we need to make sure that there is enough literacy and training to use these models, and also the dependence of private companies, which is still something that we need to work more closely.
Thank you, Felipe. This is really great. So I think that some of the things you mentioned, of course, are also applicable to other regions. You know, we need to train judiciary everywhere and raise the awareness about what these technologies are. But this is great, and also the dependency. I think related to what you said, it in a way that it's about inability to regionally, I guess, cooperate and resist as well. And it's just so difficult because all the infrastructure is dominated so strongly by the US companies and pushed, you know, into all of areas, but judiciary not exception, you know, all the various infrastructural tools that are there. Definitely a lot of them are, perhaps the vast majority would be US developed as well. So why don't we move on to, why don't we do the little gender game? Maria, what about you? Would you say something, and then we give the floor to Pablo? Would you say something, what do you think is unique to Argentina and Latin American countries more generally in this whole field of AI and Gen AI in the courts?
I think that the geopolitical landscape in Latin America is very unique, and we tend to align in different places with different countries in different times. So that's a problem, and that's the problem of the whole inter-American system. And if you study the OAS and their treaties, that's the way it is, and it has been for a long time. So I don't think that we are going to change in that. And I think that's the problem of Argentina. Argentina lacks of a state policy instead of a government policy. We change policies when we change the government. So we don't pursue an ideal or a legislation or a regulation for different topics. For example, we started with the Plan Argen AI, that's the plan for developing AI in Argentina. We have a change of government. That plan goes to the trash, and then we start another process right now because we change government again. So we don't prioritize things, and we tend to tumble over and over because we have to address economic issues. We live in a perpetual crisis, so we have other things to worry, and these things are in the background. So we don't think about these problems. For example, I talk a lot with friends that are lawyers, and I ask, what do you think about the judge using AI? And they say, I don't have problems with that. And I start, no, but you could have problems with data protection, and also they are not disclosing that they are using AI. And they don't seem to realize the problems that AI could pose to access to justice, for example. So I think that the particular challenge for Argentina is to have a consistent policy on different issues, AI being one of them.
Okay, Maria, thank you so much. We also now, I think, have a little bit of time left, so why don't we move to Pablo and see if he shares the views with you, Maria, and others. Pablo, go ahead.
Well, thank you. I just want to add something that is particular from Latin American perspective, is the issue of the influence of free trade agreements and digital trade agreements. So we are seeing a lot of different, because usually these kind of tools are not in-house, are third-party tools from businesses located outside the region. So we are dealing with all these new provisions containing FTAs and digital trade agreements regarding source code, and the issue of trying to have these clauses dealing with IP issues and the use of AI systems, and in a certain way are hindering the option of having, in a certain way, trustworthy AI tools, systems regarding, I'm thinking about issues of transparency and explainability. And if you see these new clauses, you are seeing that in a certain way, the option of scrutiny of the systems in a certain way are being a little bit more difficult. So in Latin America, we are facing all these challenges because we are very exposed to this kind of free trade agreements. That's the case, particular case of Chile. That's the case, I think, of Mexico and Colombia too, and Peru too. I think that they're very involved in the Asia-Pacific basin. You know, the Asia-Pacific basin is very active in terms of negotiating new trade agreements, very they consider that themselves as pathfinders when regulating, you know, these new technologies at international level. And we need to face this because in a certain way, these kind of provisions are hindering, you know, the option of domestically trying to regulate these kind of tools. So for me, at least, from a regulatory perspective, this is the major challenge.
Okay, thank you so much. So we covered quite a lot of different, you know, aspects of that, and I think the picture becomes a little bit more clear to outsiders. Why don't we open the floor? Somebody would like to ask a question, please raise your hand, and then, yeah, thank you so much. Please introduce yourself briefly.
Thank you to Monica, thank you to the panel, super interesting. My name is Anna Julia, I'm a postdoc at Freiburg University at the legal faculty. And we are doing comparative research, and I look to Felipe because we are looking at the Brazilian proposed AI bill. So unfortunately, there would be so many other countries to look at. Now I know, but this will be to come to Brazil. My question is, if you could delve a little more into the public perception of the judiciary in general and the judiciary using AI. Is there some evidence? Because I'm quite surprised that there is this report that it seems to be quite well researched actually. And my second question is, do you have any expectations? And if yes, which ones regarding Article 14 of the proposed AI bill? Thank you.
Thank you so much for your great two questions. Well, as the time is running out, why we don't reverse the order and maybe several sentences each would be enough. Pablo, we start with you then. If you like. If not, just pass the...
No, yeah, go ahead, Felipe. It's a long question, I think.
Well, I would focus on the first question about the public perception of the judiciary in Brazil. I would think that in general, if we ask a Brazilian in the middle of the street about what he thinks or doesn't think about the Brazilian judiciary, probably he or she would give you an answer based on political opinion. Probably he or she would say that the judges should not interfere so much intervene in political decisions, or they should be less proactive. Probably that's one of the things in a general perspective. I don't think that we have a large discussion on AI by the judiciary, by the public. Nevertheless, we have something from the bar associations. Many bar associations, they have issued a series of complaints against this use, this widespread use. For instance, in the slideshow presentation, I had a news report from Brazil in which the Bar Association from Rio de Janeiro was heavily criticizing that decision that was invented by the ChatGPT. So probably the public won't have an opinion on it, but definitely bar associations, some of them are arguing against.
Okay, would you like to add something? Please, go ahead. No? No? And what about Maria? Would you like to say something, please?
I was thinking about some studies that exist on Argentina. There are public surveys about what people think of institution in general, and normally the judicial power has a very negative view because like 20% of the Argentinians thinks that they are function correctly, and the others said that they are inefficient, that they sorry, I can remember the word, but the decisions takes too long to take place to be issued, and so on. And one of the things why the judges are using AI is to address this complaint of the public. I think if we look through the other societies in Latin America, probably we'll have a similar response.
Okay. We might have one last second question, but very quick for one speaker, please. Okay, we have two. Go ahead. And then we give the floor to you.
My name is Akemi, comes from Japan. So I'm so surprised today because in Japan, compared to the administration and the judicial problem, judiciary don't want to use the AI system in Japanese situation. So my question is, what is the motivation of the judicial power to use the AI system for research or decide automation decision? Or I'm very curious about your response to the people don't hesitate to using this kind of system, but why is the so powerful achievement for the judicial power? Please.
Okay. Thank you so much. That's a great question. So you're saying in Japan, judiciary is not very interested in the uptake of...
Maybe the lack of the declaration. So we have to, first of all, we have to do the declaration, the procedure itself.
Yeah.
So nowadays, we consider to AI, but very late process. So please inform what is the condition or what is the motivation of the judicial.
Okay, thank you. That's very interesting to hear, because you would think, Japan is such a technological society, they might as well have, so they would have the robots as judges. So why don't we give the floor to the other two speakers who didn't speak before? Please go ahead.
Great. That's a very comparative perspective and illustrative. And what's happening in Latin America? In Latin America, they are basically using it for whatever reason. Either for make them a draft of the ruling, or to help to make the processes faster and optimize them. So what's happening that LatAm countries just start using them because it was something that was put out there without any consideration, further thinking about if that could harm and how human rights. And unfortunately, sadly, it's something that we are building up. Like, we are facing violations to human rights and try to fix them. We are facing successful tools like Pretoria in Colombia, and they are being replicated. But the thing is that they don't really know how to use them. I have the luck of being training the judiciary in Latin America, mainly Colombia, Mexico, but also broadly before the Inter-American Chamber Court of Human Rights, and they don't know. They don't even realize that these tools may harm human rights. And I think that it's okay that Japan is taking their time to implement these tools, as long as they are reflecting on how they will deploy the use of these tools. So those are my 2 cents. Pablo?
So why don't we also had another question. Thank you so much for this. Please go ahead.
Okay, extremely briefly, I am Facundo from Argentina. We, the Latin American countries, are running out of a lot of resources. We don't have money. You said we need collaboration, and my connational from Argentina said we need to prioritize. Okay, what should we prioritize in considering that there's a lot of digital policies and AI implementation in the judiciary is just one? Should we prioritize this one? Should we prioritize to collaborate on having a kind of Latino GDPR, on a Latino DSA, a Latino DMA? So what should we prioritize?
Pablo, would you like to take this one?
Yeah. First, as data governance issues, AI, we need this kind of regulatory background first before start discussing the implementation of AI and stuff. I'm not convinced because if you see in Latin America, discussions are taking place right now. We are not seeing any kind of discussions related, for example, to DMA or DSA issues. DMA probably yes, DSA I'm not convinced. DGA or that Data Act, probably not yet. But I think that right now we need to start probably working hard in GDPR, in data protection issues. We have a lot of issues regarding data protection. And the point is that we are consuming all resources, discussing AI issues, and we still have these data governance issues not solved yet. So I do prefer to a good implementation of data protection issues, probably discuss this issue of cross-border flows at the regional level, because we have that problem is not solved yet. And probably after that, we can start discussing other kind of regulations, in particular AI and others. Yeah.
Okay, did we have anybody else who had an urgent need to say anything? Oh yes, go ahead, go ahead. We don't want to leave you suffering after you've spent all of this time and didn't walk away.
I'll just say, like, just the fact that you think Latin America is a concept from a sociological, historical, and political science perspective, that's a challenge. What is Latin America? So I'm starting with like the challenging perspective. Do you have one Latin America? And if you have one Latin America, do we need a GDPR, or do we just maybe need transport or data flows regulations? Because I've also heard from Latin American academics, it would be very horrible to have one kind of European GDPR because we have such different realities between countries that this would kind of erase those different realities. So my question is, should we really follow like the European GDPR, or maybe come up with something different on our own and maybe some aspects be, Latin America-wise?
Oh, great question. Would you like to go ahead, just briefly?
Briefly, totally agree. And also agree with Pablo. We need to build regulations, basic regulations for data protection, but our data protection regulations shouldn't be exactly like the GDPR. For example, there's a very problematic article within the GDPR, Article 17, regarding the right to be forgotten. Many local courts in Latin American countries, from Mexico to Argentina to Colombia, already said that the right to be forgotten is not compatible with the Inter-American system of human rights because our freedom of speech approach. So we need to build our tailor-made data protection regulation focusing on our own realities. And this is something that should be discussed broadly within our regional system. The Inter-American Commission of Human Rights and their special rapporteurs, and this can be asked for discussions before the Inter-American Court, and their decisions and their opinions are binding to many countries, or at least must be followed as guidance when deciding these kind of issues and building up new regulations.
What do you think? Thank you for your answer, Felipe.
If I have one last sentence.
Okay, off you go.
I would just say that I agree that we don't have this sense of Latin America as we should have. And that clearly has an impact on how we regulate within the region. But I would just quickly get back to the question about the comparison between Japan and Brazil. And the answer for you about Brazil is efficiency. That's why they are trying to implement this, because it's humanly impossible to deliver justice in Brazil considering the amount of processes we have right now. It's something unbearable, unimaginable how many processes we have. We have a culture of massive litigation in Brazil. So the idea is to bring justice, but we have to be careful on how we are trying to bring justice with AI, because of course we are running the risk of having an injustice delivered.
I think people are knocking on our doors, and I would like to thank all these great panelists and also Maria, who is there on the screen. So why don't we give them a round of applause? I think we can continue the debate later in the drinks. There is a party tonight, so let's go and talk about what is Latin America. So thank you all the great panelists. Thank you. Let's take a picture.